In 2019, the Defence Ministry withdrew over 60 civil appeals filed by the government in the Supreme Court against the orders of armed forces tribunals and courts in pension-related cases. Now, these were cases which ex-servicemen had won in lower courts but were being challenged by the Defence Ministry in the Supreme Court. All litigation was withdrawn from the Supreme Court and all AFT and High Court orders were implemented until 2023. But since then, the Defence Ministry has started challenging all these verdicts again. Believed to be thousands of appeals that are now pending, appeals from ex-servicemen. Joining me now on NSA is Major DP Singh, a war-wounded veteran who had to fight the system for 4 years to prove he was eligible to be treated as a battle casualty. Major DP Singh has been taking up the cause of the Defence Ministry fighting cases against disabled soldiers. Major DP, welcome to the NSA. Major DP, why is the Defence Ministry back to pursuing cases against disabled soldiers? There was a pause in 2019. There was a verdict from the Defence Minister herself asking for all these appeals to be taken back.
Where in the similar, in the same government, when two defence ministers were moving positive towards reducing the unnecessary litigation, what happened suddenly in 2023 that, the jump is in the reverse side where thousands of appeals were filed. As per my knowledge, in 2023, there were few cases which were repeatedly coming to the court, and the court had passed judgments in favor of soldiers, and when court realized that the cases are not getting implemented, they had taken a little harsh steps towards, especially the auditors and ministry, when they invited them in person and when they also, made them pay penalty in person. That is where something went wrong. Perhaps the department, the finance department and the ministry had took it maybe as a, some steps against their egos, if I can use that word. And then somebody sitting on the chair perhaps realized कि अभी हम उनको दोबारा से lesson सिखाते हैं. Because I fail to understand कि same government में दो defense minister were of the opinion which was helping everybody. Why I am saying helping everybody? Because if you are raising appeals, you are paying lakhs and rupees to the legal people who are fighting cases against these soldiers who are asking for peanuts, which is also their due, not an illegal thing.
Major DP, what do you suggest that the MoD do to make the process a little more responsive and speed it up so that the families of these disabled soldiers, the soldiers themselves, get relief at the earliest?
See, Sandeep, the issue is not about families getting immediate support in the system, because in the armed forces we have a beautiful system. As and when there is a death case of any such nature, family does get the immediate support from the regiment, from the armed forces. The issue lies here in the cases particularly where a soldier is getting disabled, which is not accepted as attributable by the army headquarters or the armed forces headquarters. That is where the issue lies. Because then he has been sent, because of he being not fit to serve further, high and dry, out of the service. Now imagine 28, 29, 30 years old soldier going out high and dry and trying to defend himself, and maybe at times he gets married also, his family, with disability, either with a very meager pension or with no pension.
There's also this issue of conditions attributable to military service, where the rules say that there are some ailments which cannot be attributed to military service and therefore you don't get pensions for that. What's your take on that?
Hypertension, heart attack are the things which were incorporated in the normal disability pension earlier, because there was a liberalized view towards these things, that if a forces personnel is employed or designated at a duty in the harsh areas, there is a likelihood of him or her getting such ailments. But they say नहीं, तुम तो फौजी हो यार, तुम तो फिट हो, तुम इतने सुपर हीरो हो कि तुम्हारे को हार्ट अटैक हो ही नहीं सकता. अगर हो गया, that means it is your fault. not the
Right.
fault of service is the condition.
So these are
So this is
conditions
funny.
attributable to military service.
Exactly. Those, so the disability which used to earlier, maybe for hypertension, it used to be around 30% or so, has been reduced drastically to 5%, because anything less than 20%, you are not liable to get the pension or disability part of the pension. So smartly, the rules have been changed to bring it down to such percentage that it has been given to you as a disability, but you are not getting any financial benefit out of it. So I fail to understand why this smartness has, from where this smartness is coming to.
Major DP, thank you for joining us. We can only hope that the Defense Ministry takes a more lenient view when it comes to our soldiers who've been giving their best years and their life and their limbs to defend the country.